Hello friends, in the series on the income tax cases, today we will discuss a case which is based on the monetary limits for issuing the notices of scrutiny assessments, whether it is a notice under section 143 subsection 3 or whether it is a notice under section 148. There is a notification or there is an instruction of the Central Board of Direct Taxes, that is number 1 of 2011, which sets out the limit for completing the assessments by the assessing officers and by the assistant and deputy commissioners. According to that instruction, if an assessee is in a metro city and is a corporate assessee and his income is 30 lakh or more, then in that case the assessment of that assessee, corporate assessee, should be done by assistant commissioner and deputy commissioner. But in this case the notice was issued by the assessing officer. So this case is regarding that if this notice is issued by not a proper officer according to this instruction, so what will be the fate of those assessments? This case has been decided by Calcutta High Court, and the name of the case is Principal Commissioner of Income Tax versus Shree Shoppers Ltd, and the matter has been reported in 468 ITR at page number 18, and the date of the judgment is 15th March 2023. The case relates to the assessment year 12-13, and a notice under section 143 subsection 2 was issued for completing the assessment under section 143 subsection 3. The assessee was from the very beginning challenging this notice and assessment by taking a ground that in the present case the jurisdiction of the assessee lies with the assistant commissioner or the deputy commissioner according to instruction number 1 of 2011 of the Central Board of Direct Taxes, but the notice has been issued by the assessing officer, so the whole assessment proceedings is void. The assessing officer and the CIT appeal didn't take any heed to this objection of the assessee, because we have seen in our practice that whatever the grounds which are legal in nature, which are technical in nature, or which are relating to the jurisdiction of the assessing officers are neither entertained by the learned assessing officers and by the learned Commissioner of Income Tax Appeals. It seems logical that if the assessing officer does not listen those things, then it may be justified to some extent, but it is very painful when the CIT appeal, that is the first appellate authority, does not hear these grounds. So the assessee has to take the burden of carrying these matters to the tribunal unnecessarily. But this is the real situation that CIT appeal will not entertain, or they do not entertain for the reasons best known to them, any legal ground, although there are sufficient material or sufficient number of the cases decided by higher courts to support the case of the assessee, but the assessee's legal grounds are not entertained by the Commissioner of Income Tax Appeals also. But in the present case, when the matter was carried to the tribunal said that the jurisdiction of the assessee was with the assistant commissioner according to the instruction number 1 of 2011. Since the assessee falls in a metro city and he is a corporate assessee, so the whole assessment proceedings are without jurisdiction. The revenue carried this matter to the High Court, and the High Court also said that in the present case the defect in issuing the notice, that is without jurisdiction, is incurable and went to the root of the matter. So the assessment proceedings are quashed on this ground. Friends, this case is very important, because whenever you receive the notice, you just compare your income tax return with the quantum of the income, and then compare with instruction number 1 of 2011 that whether the notice is to be issued by AO or by ACDC. If the notice is not issued by the proper officer, then the assessment will not be as per the instruction number 1 of 2011, and it can be quashed by the higher courts. At the end of this video, once again, I am repeating the name of the case. The name of the case is Principal Commissioner of Income Tax versus Shree Shoppers Ltd, and the matter has been decided by Honorable Calcutta High Court on 15th March 2023 in a appeal matter. Thank you, friends.